This conference will now be recorded.
So I'd like to welcome everybody. It is Friday, September 11th, 2020, and today's topic is how to be an advocate and an effective one for either a nursing home resident or a rehab patient. Now, this has always been an important topic, but probably since the pandemic began in mid-March this year, it's become more important than ever, since governors in all the states had to issue orders to quarantine people that are in facilities, whether they are nursing facilities, assisted living facilities, homes for the developmentally disabled. And those orders were, of course, issued in order to try to keep the residents healthy and as safe as possible. So we're going to talk a little bit in the beginning about what is called the Nursing Home Reform Law. We're going to talk about Medicare rules, and then we are going to transition to talk about our governor's new order that was published last week and talk a little bit about how does that help people that are in Florida facilities and what can all of us do to be strong, effective advocates on their behalf. So as I said, we're going to talk in the beginning about a very important foundation for today's discussion, which is the Federal Nursing Home Reform Law. And this is a federal law that applies to every state in the country when a facility chooses to become certified to either receive Medicare funding or Medicaid funding to take care of its patients or its residents. Now, what's important to understand is why this law came about. There were, prior to this, very few guidelines that were being followed in an effective way state to state. And so groups became formed, they got together, they contacted their representatives in Congress, and that led to the Federal Nursing Home Reform Law. Now, there's two important aspects to this. The first is that the law talks very strongly about the responsibility of facilities to help their residents attain and maintain the highest practicable physical, mental, psychosocial well-being, which basically translates into quality of care. And the second responsibility it places on the facilities is that they have to be able to promote the maintenance as well as enhancement of the quality of life of a resident. And one of the ways that they do this is through a two-step process. There is the comprehensive plan of care, and there's the baseline plan. Now, the baseline plan is required to be completed within the first 2 weeks that a new resident comes into a facility. The comprehensive plan of care is something that is not just done initially, but it is continued to be done, and it's a work in progress month to month and year to year for each resident, because as the needs of a resident changes, the plan of care has to adapt accordingly. If somebody is doing better, they may need less services in certain areas, or they might need those services continued to stay at the level they've achieved. So that is something that is in a process. It's progressively being reworked. The other thing that the facilities, at least at the nursing home level, are required to do is to hold a care plan meeting. Now, sometimes this is done monthly, sometimes it's done quarterly. But to be an effective advocate, one of the first things people need to know is that these meetings do take place, and members of the resident's family or their supportive team, if you want to call it that, which could include a life care manager, could include a neighbor, a friend of many years. they can attend the care plan meetings. And not only can they really should, because it's an opportunity to sit and meet with all the professionals in the facility. So the director of nursing, the director of social services, the director of dietary needs, the head of physical and occupational therapy. So it's an opportunity to dialogue and understand the role that each of those professionals are playing in carrying forth the comprehensive plan of care. And it's an opportunity for that life care manager or the family member or the friend to offer suggestions, to ask questions. So this is something that we want people to understand is really the first place that they can learn to be a strong, effective advocate. And if you think about that old saying that the squeaky wheel gets all the grease, it's very true here. We need to help people feel that there is a way in their comfort zone that they can speak up, be an advocate, be passionate about what they're advocating for, and do it in an effective way to get the desired result, which is to get quality of life and quality of care for the resident or the patient. Now, it's important to know that if a facility violates the nursing home reform law, the ultimate result is that they can no longer participate in the Medicare program or the Medicaid program. So this is another important piece of information for advocates to understand. And it's not necessarily meaning that we want everybody to go in there with guns blazing, but there is a way to talk and get people to understand what is important for the resident and get the desired result. Now, we would need more time than just the hour we have together to actually go through the entire list of all the legal rights that a nursing home resident has when they move into a facility. So I've chosen a few of the ones that I want to highlight and I think are probably the most important. Doesn't mean the other rights aren't as important, but these are ones that we're going to touch on today, and again, making it relevant to what's happening with COVID-19 are probably more important given that people are being quarantined. There are feelings of being secluded and alienated, which are affecting a resident's psychosocial well-being. So at the top of the list, you'll see that I put that a resident is entitled to have private, uncensored communications, which simply means if they get mail, nobody should be opening up that mail for them. Or let's say somebody does not have a cell phone and they're relying on a landline phone, nobody should be listening in on their conversation. The second right is the right to visitation, which unfortunately has been severely impacted because of the quarantine due to the virus. But we're going to get to that a little bit later in today's discussion. The third right I've listed is that a resident has the right not just to access a physician, but to actually choose a physician that they prefer. They're entitled to access law enforcement, which means if they feel that there is a criminal matter, they should be entitled to speak with the police. And most important, they are entitled to have access to the county's long-term care ombudsman. So for those people who are joining us today and have never heard the term long-term care ombudsman, every county and every state has an ombudsman that has been appointed by the governor. Some counties may have multiple, not just a single ombudsman because the need of that county is greater, or it may be a metropolitan-based county as opposed to a rural county. And the role of the ombudsman is to be an advocate for residents of nursing facilities as well as assisted living facilities. And to help them carry out their role effectively, they are given certain rights, which include the right to enter a facility without having an appointment. And sometimes there's a need to do that. We don't want the ombudsman to call ahead and let the facility know that they're showing up. There may be a specific issue that needs to be investigated. And so that element of surprise is important to the ombudsman being effective. Once the ombudsman is in the facility, they have a right to look at a resident's chart, to meet with and speak with the resident, to interview other residents and or staff, employees of the facility. And if they believe that there has been a violation, then they are going to include that in their report, and then appropriate steps are taken from there. So having access to the ombudsman is important, because if a resident feels that any of their rights are being violated, they should feel that they can speak with the ombudsman and that they're going to be free from any type of retaliation from the facility or its staff should they decide to present their grievance or have the ombudsman present the grievance on their behalf. When a person goes into a nursing home, they don't lose their federal rights that we all have to decide who we're going to socialize with, to continue with our preferred religious observances, or to participate in community activities. So these rights continue as a nursing home resident. Now you'll see in the middle of the slide, I've highlighted something that's very important, which is that a resident has the right to view the facility surveys. So the Agency for Healthcare Administration is our state agency that oversees many important aspects of nursing facilities and assisted living facilities. So starting with the licensing process and extending all the way to annual surveys that are done on site at the facility. So I'm providing you with the ACA website and the specific link for the page that people can go to when they are in a position where maybe they need to place a loved one in a nursing facility, to help them understand what to look for, and that not every nursing facility may provide the services they need. If the individual has, for example, a piece of equipment, it could be a respirator, it could be a trach tube. So this guide is very helpful to tell the consumers what kinds of levels of skilled care services can be provided. It's also going to show the consumer what came out of the last survey. What did ACA find when they went in? Were there any deficiencies that the facility was cited for? And what were those deficiencies? And were they corrected? Because that's most important of all. So this is a great tool that anybody who's going to be an advocate needs to have in their toolbox. Another important right is to be able to access social, health, and legal services, which means that if a private social worker, life care manager, elder law attorney needs to go see a resident, they are entitled to meet with that professional. Another very important legal right is the right to privacy as it regards the person's physical body and the room that they are living in, which means that if they have a visitor, they have a right to close the door and to have privacy. When they're changing, they have the right to close the door, and before a staff member enters, to require that staff member to knock and wait for a response. The resident also has the right to have the facility inform them of charges, anything that is out of the ordinary, as well as what charges are not covered by Medicare and or Medicaid. And tied into that, they have a right to be told what is the facility's policy on a bed hold, should the resident need to be taken to a hospital unexpectedly. And you'll find that there is a different bed reservation policy if the resident is paying privately for their room and services compared to a resident who is receiving Medicaid assistance. Then we have to look to the Medicaid rules, and generally speaking in Florida, that is an 8-day bed hold policy, and any time after that period that's covered by Medicaid would have to be private pay to hold the bed ongoing. Also related to the bed reservation policy is the resident should be informed what the refund policy is for that facility and how many days would they need to give the facility notice if they're going to move and relocate. Just like the resident has the right to choose their own physician, they have the right to also select the pharmacy of their choice. So these are just a few, but not by any means all of the legal rights that a resident in a nursing facility has. So another area that we need to understand as advocates to be strong and effective for the resident is, what is the resident's rights should they receive a discharge notice? And this is certainly an area that a lot of people are unfortunately caught off guard. And we don't want that. We want people to be informed, to have the information so they know the steps to take. So the first important thing to know is a facility must provide the notice in writing. To tell somebody verbally is not only not acceptable, it doesn't meet the legal requirements. In the written notice, there are certain things that must be provided. For example, the facility must give the resident 30 days advance notice. Anything less than that is illegal and can be the basis for the discharge being contested. In addition, the facility must indicate in the written notice what is the location of discharge. For example, is the person being discharged to another facility? If so, they have to identify what that facility is. One of the things that I've seen over the years, and I hope that it is not continuing, is that facilities would write that the discharge location was the resident's home. Well, that's not allowed if there's nobody there at the home to take care of the resident, or the resident has such high levels of skilled needs that there's no way that those needs could be met in their private home. So they can't just simply come up on their own with some discharge location. They need to consult with the resident or the resident's legal representative, and it has to be conducive to the resident's needs at that time. So written notice is required. They must indicate the location for discharge. They must provide 30 days advance notice, and the discharge notice must also very clearly cite what is the reason for the discharge. If there is no reason listed, that by itself is going to lead to a successful contesting of the discharge notice. Now, there are 4 legal, meaning valid, grounds for discharging a nursing home resident. The first ground is that the nursing home resident or their legal representative has failed to pay the bill after they've gotten reasonable notice. Now, it is not a valid ground to discharge a resident simply because the form of payment has changed. And what I mean is, if we have a resident that initially came in as a private pay resident or as a Medicare paying resident, and they then qualify for Florida Medicaid assistance, just because the source of payment has changed is not a valid basis for seeking to discharge the resident. That is illegal. It's only if reasonable notice has been given, the bill has not been paid. The second valid basis for discharging a resident is because the resident's health has improved, meaning the resident no longer requires a skilled level of care. Perhaps they've improved to such a point that now it would be safe for them to reside in an assisted living facility where there's still supervision, there's preparation of meals, there's laundry and linen services provided, but they don't need the skilled nursing component. Now, it's, again, not a valid basis if the facility tries to discharge a resident saying the health has improved, but the person is actually at the same level. And the simple reason that's not a valid ground is because before an individual is accepted into a licensed nursing facility in Florida, they go through an assessment process, which means that the nursing facility knows what the individual's diagnosis is, their prognosis, they understand their condition, and therefore they understand what the needs are. The third basis for a valid discharge is that there's something that the resident is doing that is imposing a safety risk or safety hazard to the health and well-being of the other residents who live at the facility. So this might, for example, entail a resident who not only has nursing level needs, but also may have a mental illness. Every situation has to be evaluated on its own merits. We really can't, in today's webinar, try to evaluate situations that may arise, but know that they would specifically have to present facts and evidence to show what it is that the nursing home resident is doing that creates that hazard or jeopardy to the safety and well-being of the other residents. One thing that we've seen over the years is that, for example, a resident might be a long-time smoker. And so the facility, in order to keep everybody else safe, will instruct the resident, you cannot smoke in your room, you cannot smoke inside the building, but there are certain areas outside, like a sitting area, that have an ashtray, and there it's safe for you to smoke. So what we're seeing in that example is that the facility has made reasonable accommodations to accommodate the fact that that resident likes to smoke. And by doing so, that resident is not creating any kind of hazard to the safety and well-being of the other residents. The fourth valid reason for a discharge is that the resident's needs can no longer be met. This is a very high level that a nursing home would have to meet for the discharge to be valid. Again, simply because they do the assessment in the beginning before even accepting a person to be a resident, and therefore to then make this statement that the needs can no longer be met, they really have to have concrete, hard evidence to show what exactly changed. Now, I hope that you're looking at the bottom of this slide because this is a very important tip. So this is an important takeaway for today. You want to counsel your clients, your family members, your neighbors, that if they receive a notice of discharge, they need to file the appeal within 10 days of receiving that notice, because if they file within 10 days, the discharge is automatically stayed until there is an administrative hearing. But if they wait and they file the appeal on the 11th or the 12th day, it is too late, which means that if the hearing cannot be scheduled until after the discharge, the 30th day has occurred, unfortunately, that cannot be stopped. So it is so important to file the request for appeal with the Agency for Healthcare Administration within the 10 days. Now, we've been talking mostly about nursing home residents, and we don't want to forget that before somebody becomes a nursing home resident, it's very likely that they're coming from a hospital stay into the rehab part of the facility. So we need to be effective advocates when a hospital patient is discharged. So we're going to go over some very important Medicare reimbursement rules and how do you advocate for somebody that is receiving therapy in the rehab area. So the first thing to understand is that Medicare is only going to provide coverage if that person has been in the hospital for 3 days. It will not work if they're there for 1 or 2 days and then they're discharged to the rehab. And the hospitalization has to have occurred within the prior 30 days. Now, while I don't think this happens, I do want to mention to everybody that is listening today that if somebody meets the 3-day requirement but goes home first and then goes to rehab, that won't work. You must go directly from the hospital to the rehabilitation facility. Now, in the last year to 2 years, there's been changes. And what we're seeing happen is sometimes somebody is admitted through the emergency room, but they actually never get formally admitted into the hospital. And this is dangerous because if they go from the emergency room to the rehabilitation facility, there is not going to be Medicare reimbursement. So this is a really important point to pick up. We must strongly advocate that they be directly admitted from the ER into the hospital because without that, there is not going to be Medicare coverage. The second requirement to get Medicare to pay is it has to show in the patient's chart that this person needs either skilled rehabilitation or skilled nursing services. And this is where we need the physician to be our advocate, to be our team member. Now, if those requirements are met, then Medicare is going to pay 100% from the first day of admission through the 20th day. Now, around day 20 is when we start to see the team of professionals reevaluating the patient, reevaluating their need for physical therapy, occupational therapy, speech therapy, or even restorative therapy. Now, if therapies are going to continue, then Medicare will cover 80% from days 21 through day 100. But at day 100, under the federal Medicare rules, the coverage is going to stop for everybody. There are no exceptions written into those Medicare rules. Now, it is important that people understand that there are limits within Medicare. So, for example, you see the limitations on the percentages covered. There's also limits as to how many hospital days will be covered and how many lifetime hospital days we all are going to receive. So for that reason, we want to become educated and help the person we're advocating on behalf of understand that it will be important if they have traditional Medicare for them to consider a Medicare supplement. It's also called a Medigap policy, so that where there are gaps in the Medicare reimbursement system, such as days 21 through day 100, they have the ability to have the Medicare supplement pay the remaining 20% copay, rather than it having to come out of the pocket of the individual. Now, federal law has standardized the different types of Medicare supplement policies, so it doesn't matter who is selling them, whether it's United Healthcare or AARP or somebody else. Each plan has to provide standardized services. Now, what happens if you are a family member, a friend, or an advocate for somebody in a rehabilitation facility, and you're told on day 20 that the staff just doesn't think Medicare is going to continue to pay. So now we're going to talk about something called demand billing, which means rather than the facility making that guess, that determination of what will Medicare do, you can require the facility to continue to provide services and submit the billing to CMS, the Center for Medicare and Medicaid Services in Washington, D.C. If Medicare approves it, the facility is going to be paid. If for some reason Medicare is going to disapprove the billing request, the claim, then the person who's in there or their advocate has the right to challenge it, to file an appeal. And this is where it's going to be very important to get the physician on board. Perhaps there might not have been proper or enough documentation in the record to show that the services were necessary. So we're going to talk a little bit more in detail about other things that are important to know with the demand billing process. Have you ever heard the phrase or the statement, well, we're going to stop the therapy because the patient just isn't making progress, we're not seeing improvement? This was a phrase that has been used for a very long time, and for unsuspecting consumers or their advocates, they just didn't fight it. They accepted what they were told, and at that point in time, either the resident was going to private pay for any therapies to continue, or they were going to be moved from rehab into the skilled nursing side of the building. Well, that is now changed. So about 2 years ago, several of our advocacy groups based in Washington got together, and thanks to them, we do have a change in the law. So what was called the improvement standard is no longer the law. And I'm providing you with a great website, medicareadvocacy.org, that you can go to, and they have some great tools on their website, including a page you can print out of frequently asked questions. Now, the case that actually got tried in the court system that helped to lead to the change is called the JIMO case, J-I-M-M-O. And so JIMO sued the head of the Department of Health and Human Services to create this change in the standard. Now, the new standard and Medicare applies to skilled nursing, rehab services, home health services, as well as therapies that somebody might receive as an outpatient, meaning they've gone back to living in their home, but they're going to an outpatient center to receive the therapies. So here's what you need to know to be an effective advocate. If the therapy is necessary to maintain the patient's level of function, and there are many different types of functions that are important to everyday life, that is enough to tell the facility you are not to stop the therapy. The second thing you want to focus on is the therapy necessary and should be continued because we want to prevent or we want to slow any decline due to a chronic illness. So for example, let's say we have a person who has been diagnosed with Parkinson's disease, and they were hospitalized. They've been discharged from the hospital. They're in the rehab facility, and the head of the therapy department is frustrated because the Parkinson's affects the individual's ability perhaps to follow instruction, or they're proceeding with the instruction much slower than another patient might. And so they decide that they're going to stop therapy because this individual just isn't making progress. We're not seeing any improvement. Well, we would want to argue that those therapies should continue because we do not want this patient to decline due to the Parkinson's disease. And that is a valid basis. The third tip you want to be aware of is that if the individual receiving the therapies has been diagnosed with dementia, that is no longer a disqualifying reason to stop the therapies. You know, it might be that somebody has more difficulty following instruction because of the dementia or the cognitive decline. But that doesn't mean that they have a right to stop the therapies. So I hope that you mark down this website. It has wonderful information and it's very consumer friendly. Another area that it's very important to be an effective advocate for a nursing home resident is right at the time of admission. And why is that? Well, nobody is going to be admitted without there being a signed written contract. And unfortunately, this is one area in which we continue to see facilities either including language or including requirements that are not permitted under the federal nursing home reform law. So we're going to walk through a couple of things that I tend to see when my clients come to me first, which I encourage everybody to do. Let the elder law attorney review the contract before you sign it. The first thing you'll see in the PowerPoint presentation is that a third-party guarantee is prohibited. Now, they're not going to use the language third-party guarantee, but the language you're going to see in contracts is responsible party. And it means the same thing. They're trying to hold somebody other than the resident personally, financially responsible for the payment. Could be that they're going to try to hold an adult child or another relative responsible, and this is not allowed. So if you see these words below a signature line, you want to cross them out. And let's say as the advocate, maybe you are the agent under a durable power of attorney that gives you permission to sign the admission contract. Then what you're going to put below the line is exactly that you're the agent under the durable power of attorney. Or maybe you're the legally appointed guardian for the resident. So again, you're going to cross out the words responsible party and you're going to write legal guardian or court-appointed guardian. Now this is what we suggest if the resident is not competent. The resident cannot understand what they are signing. Of course, our preference is that the resident, when competent, should sign the agreement, but still it's so important to have the contract reviewed first by the elder law attorney. The second thing that we will sometimes see is facilities trying to do what I call financial screening, meaning they'll say, here's the admission agreement, and when you return it, we'd also like to see 3 months worth of your financial statements. This is a no-no. This is prohibited under the federal nursing home reform law. They're not allowed to do that. The third thing that we'll sometimes see either in the contract or in a separate document is the facility trying to require the resident to privately pay for a certain specified period of time. Again, this is not permitted. They cannot say something like, well, you need to private pay for a year and then you could go ahead and you can apply for Florida Medicaid assistance. They cannot do that. And just because a resident was admitted initially as a private pay resident and then 3 months or 4 months down the road applied and was approved to receive Medicaid assistance, remember, it's not a basis for discharge. Another thing that a facility cannot do, and if we see this language, we want to cross it out, is to try to get a resident to waive their rights under the Nursing Home Bill of Rights. A facility can actually be fined if it's caught doing that. So no resident should be required to give up any legal rights simply by moving into a nursing facility. Sometimes we'll see language that in the contract says that the resident is waiving any liability to hold the facility accountable if there's a loss of personal property. I do not recommend agreeing to that either. The big one we see, and unfortunately I still see this in contracts today, is they include, and it's usually more than one paragraph, it's pretty lengthy, requiring a resident to agree that if there's any kind of dispute between the resident and the facility, that they will submit to what is called arbitration. Arbitration is a legal method to try to resolve a dispute. However, arbitration is binding. So if a resident or their advocate agreed to this paragraph, it means that they're not going to have the opportunity to do anything else, such as mediation, which is a way of trying to resolve a dispute, but it's not binding. It also means that the nursing home resident would not be able to file a lawsuit because they agreed to arbitration. So this is not permitted, but I am seeing this included in contracts. So please be very careful when you advocate for somebody that is about to be admitted to a nursing facility. Now, if a facility that you've toured for whatever reason says, oh, we don't have a bed available, here's another tool for your toolbox. You can tell them, well, you can submit a request to the Agency for Healthcare Administration to certify more beds for somebody who's either on Medicaid, transferring from another facility, or somebody who anticipates applying and being approved for Medicaid assistance. And they can do that. It's a very simple form, and it can be emailed or faxed up to Tallahassee. So now we're going to talk about Florida's new update that came out last week on September 2nd, 2020. Now, this update applies to group homes, foster care facilities, mental health and treatment centers, long-term care hospitals, nursing homes, intermediate care facilities for the developmentally disabled, assisted living facilities, as well as adult family care homes. So all these facilities that are licensed by ACA must now follow this new update. So here's what we're learning about it in the very short week that has passed. We do know that during the quarantine, if a resident was certified as being at end of life, on a very limited basis, family, friends, and individuals were allowed to visit the resident. That has not changed. That is staying the same. We also know during this quarantine that anybody who is employed by hospice or is a palliative care worker also will be able to go into a facility. Something you may not know, and this has been questioned the last 6 months, is whether attorneys are considered to be an essential worker allowed to come in and meet with their clients. And actually the answer is yes. And one example I've given you is that if somebody is in a mental health facility and they have an attorney either appointed for them by the court or they have a private attorney, they are entitled to access their client in regard to that proceeding. Same applies if a guardianship proceeding is filed for somebody. Their court-appointed attorney or their private retained attorney is allowed to have access. So is a guardian. You heard me talk earlier about the role that an ombudsman plays, and that an ombudsman has the right to enter and visit with a nursing home resident. That stays the same. Now what has come out of this new order as of last week is that a resident can designate or just authorize 2 essential caregivers to be able to enter and meet with them. Now this is under the condition that the resident themselves is not currently positive for the COVID-19 virus. all the rules about wearing a mask, using protective personal equipment, exercising social distancing, and going through a screening process still apply and are still going to be enforced. But now the news is that a resident can have up to 5 general visitors, which means they don't have to fall within that category of being an essential worker, but they can have 5 general visitors. 2 people can visit at a time. Okay, here's what is important. The staff must be COVID-free. The residents must be COVID-free for the prior 14-day period. If a facility is able to meet that requirement, then they can allow the visitation. Now, the preference is to provide an area that's safe for the resident, outdoors preferably, or as you can see from the weather we've been having this week, we've had a lot of rain. That might not be feasible. So the facility does need to provide a safe area within the building for the visitation to occur. So this is great news. I'm hoping that this is going to start to make a difference for our residents as well as their families and their loved ones who for many months now have been worried and concerned about the well-being, and some people who just are not able to either speak on a phone or communicate through a device like an iPad. So I'm really hoping that we're going to start to see some positive changes as a result. So I'd like to give you some recommendations and some more tips as we conclude today's webinar on how you can become an effective advocate. There are family councils at some facilities. You might want to join the family council, and that's a great way to learn to be an effective advocate and meet with the facility administrator. Or you might be a leader and you might form a family council. There's a lot of great information on the internet about how to go about being an active member or forming a family council. It might sound common sense, but don't overlook the fact that visiting often is very important to being an effective advocate, and going at different times of the day and night. You might observe different things about staffing or the response time of how a staff member responds to a resident. That is so important that they know there are eyes and ears watching. My third suggestion is we have a wonderful profession known as aging life care managers. You'll find them all over the country. They're helpful not just when family does not reside in the same city, town, or state, but even when we do have family, they are just a wonderful resource to educate our families on how to navigate through the healthcare system, how to find the proper services, making sure that our loved ones are being seen and they're not missing their doctor appointments. And remember, in every county, we have the Long-Term Care Ombudsman Office, so please reach out to them. You can also go online to www.naela.org. That is the National Academy of Elder Law Attorneys, to find an elder law attorney to help you in your area of the country. And the last resource I'd like to share with you is called National Consumer Voice for Quality Long-Term Care, as well as the National Center on Elder Abuse. They have wonderful resources on their website. They also have educational forums. They hold webinars throughout the year. And just this week, they released 2 pieces that you'll find on their website. The first one is called Taking Care of You, Tips for Residents of Long-Term Care Facilities. And the second one is called Taking Care of You, Tips for Family Caregivers. I read both of these. They have some great links and suggestions. So again, these are tools for your toolbox to be a strong and effective advocate. So I want to thank everybody for joining me today and open it up now for questions. You're welcome to either unmute your microphone or write a question in the chat box. So it seems that we don't have any questions today. Oh,
Hi.
Debbie?
No, I just unmuted. I just want to thank you. I always learn something new every time I do join your seminar, so I want to thank you.
Oh, thank you so much, Debbie. I'm glad you're here. Did somebody else have a question?
This is Kathy. Can you hear me okay?
I can.
Okay, I just have one clarification about the doctor. Okay.
Kathy, go ahead and repeat it.
Okay, thank you. I think I was muted. Question about the choice of going to a doctor that you might want to go to. Let me make sure I'm clear about that. My understanding is that if you're in rehab, yes, you can make arrangements to go out to see a physician of your choice. But if you are in a long-term facility, they usually have doctors that are credentialed by the facility to come in. And so is there a workaround around that? I know that some of my nursing home clients in the long term have been able to get transportation and go out to a doctor of their choice, but normally the in-house physicians are normally the ones that see them. I hope I'm communicating that clearly.
Yes, no, I understand what you're saying, and you are correct that there'll be a medical director for the nursing facility. And similar to when somebody's in a hospital, you may have to ask if the primary physician that the resident has used for years has privileges to go into the facility. If not, you may, as the healthcare advocate, need to help arrange for transportation so they can go to the doctor's office of their preference.
Right, that's been the way that my understanding is. Okay, and then the thing about the telling them that you have to go, hold on one second, I put a note down here. That was about their, that they made, the demand billing. I guess I've never heard that term before. So can you just clarify that, how that works?
Sure, I'd be happy to. So demand billing means that at the time a person is in the rehabilitation facility and might be told, we're not going to submit a claim to Medicare because we just don't think Medicare is going to reimburse us.
Right.
That the patient or their advocate or their legal representative can say, no, you need to go through the claims process.
Okay.
And while you're waiting to receive Medicare's decision, you will continue to provide the therapies to me.
Okay. And so, but when did they generally, how much notice did they generally give you for that? Because if they're telling me, I get calls, hi, my mom's being discharged like in 2 days or tomorrow, it's like, who's the payer source if they're declined, I guess?
So if the facility then submits the billing to Medicare and Medicare denies it, there's two other options. One is then the patient has to be personally taking care of the cost, or they can appeal it, and that's where you need the support of the physician.
Right. Okay. So to proact, which is what I try to advise clients and myself if I'm hands-on with the case, yes, I think the importance is monitoring and having a conversation with maybe the director of rehab while they're there, under their, days 1 to 20, right? And not wait the day before when they're ready to discharge. So let them know proactively that you would like to be kept abreast of how they're, if they're, what's the word, if they're adhering to the skillable, the skills.
Correct. Or do they just need custodial care at that point? And let's remember that now what we used to call, or not we, but the facilities would call that improvement standard has changed.
Right. Good.
And so that's something, you know, when all of you are working with an individual or families, you probably want to educate them about as they're going from the hospital to the rehabilitation center. Because that's where we can really use that as a tool to make sure the facility is doing the right thing.
Okay, okay. And now I don't think this is addressed here today, although it might have been. What happens when they're, I got a call from a client that was positive, and they're going to discharge them from the hospital. And they live in what do you call it? They live in assisted living, who won't take them back. So where's that person supposed to go from the hospital if they're testing COVID? Has that been addressed under that? Is that under that new law as well, from the hospital, or just rehab and nursing homes?
Just nursing homes, rehabs, and the other types of facilities. But if the person does need therapies, the hospital, you know, whether it's their discharge plan or their care manager, should know what facilities are accepting COVID positive patients.
Right. Okay, that's what I thought. Right, I thought. Okay, that sounds great. You're amazing with this. I look forward to grabbing it off the internet. Thank you so much for taking the time to educate us, and especially me.
Thanks for your questions, Kathy. So our next webinar is at the end of the month, Friday, September 25th, again at 12:30 p.m. And this webinar is going to focus on reasons why fiduciaries need an elder law attorney. So tune in to find out what is a fiduciary, because you might be one and not realize it. And it's important that you know some of the things that a fiduciary is responsible for. So you can go to my website, www.fl-elderlaw.com, to our calendar page to register for an upcoming webinar. And if you registered but something came up unexpected and you missed it, go to the resource page and you can watch the recording. And also on our Contact Us page of the website are complimentary gift certificates for you to use personally, for you to give to your clients or loved ones. And I look forward to seeing everybody very soon. Thank you for being with me. Stay healthy and safe and have a great weekend.